Welcome to our continuing 2022 educational webinar series. I am Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business. A hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility, and we help manage every aspect of a compliance program, and our training library provides hundreds of modules that are easy to assign and track. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Catherine Walters, a management side labor and employment attorney representing employers of all sizes, including privately and publicly held companies, federal and state government contractors, institutions of higher education, trade associations, and other nonprofit industries served, including financial and banking, manufacturing, defense contracting, education, healthcare, professional services, insurance, construction, technology, retail, real estate, transportation, restaurant, and hospitality. Catherine partners with clients to develop creative, practical, business-oriented solutions, and she focuses on identifying current and emerging trends to assist clients with managing and preventing emerging risks. Emphasizing strategic thinking and focused solutions, Catherine provides employers with the sophisticated counsel that has become necessary in today's complex business environment. She appears before federal and state courts and administrative agencies, and currently is a partner at BYBEL Rutledge LLP. Before we begin, I would like to mention at First Healthcare Compliance, we strive to serve as a trusted resource for compliance professionals, and every month we celebrate their hard work and dedication with our Compliance Super Ninja recognition. For this Super Ninja, our team is turning the spotlight on Mindy Mayberry, Practice Administrator at ENT Specialist PC. Mindy says, I have the best group of physicians and staff. We have a close-knit team at ENT Specialists, PC, that we consider family. Congratulations, Mindy. Our team is honored to have the privilege of working with you. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your PAYCOM and PMI CEU certificates will be emailed to you following the broadcast. Your PAYCOM certificate will come directly from PAYCOM, and your PMI certificate will come from our email. There is no need to request either one. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. So, Catherine, a very warm welcome. We are very excited to have you here today.
Well, thank you so much, Catherine, and I'm very excited to be here. And I'd like to send my own congratulations to Mindy Mayberry, the ninja, and basically say good afternoon to everybody. There's what is considered to be a Chinese curse that says, may he live in interesting times. Well, we are certainly living in interesting times. And really the gist of the alleged curse is that life is better in uninteresting times of peace and tranquility than in interesting times, which are usually times of trouble. And so, of course, we turn our attention to today's agenda, which really I've labeled, there's so many things to cover, but trying to fit everything into 1 hour, I've given you a nice array of interesting topics today. We're going to cover quite a few things. The key word for me is change. 2020 and 2021 resulted in lots of change in how we work, change in how we adapt or do not adapt, change in our workforce, change in both employer and employee expectations. Today we'll talk about COVID and change. I'm going to touch a little bit on the Biden labor agenda because it's so relevant to all of the things that we are anticipating in the coming years. I'm going to do a brief 2021 in review, and then we're going to talk about 2022 in terms of a forecast and what to expect. Then I've got a couple of hot topics lined up, and we'll just keep going until we run out of time on those things. So let's focus on the now ever-present COVID-19 and variants. Basically, COVID-19 has changed the way we work. So we have always posit this question, is this the new normal? Is it the new future? We are dealing now with all kinds of workplaces, remote workplaces, hybrid workplaces. We've got the in-person workplaces. A lot of employees are unhappy because they would like to work remotely, but they have in-person jobs. So we ask ourselves, what do employees want? What is the government doing or not doing to help? And running throughout this is, of course, the lesson of adapt or die. We've lost so many small businesses, and yet we've gained so many new ones as people tried to retool and they looked at what they could be doing from home, what the impact of COVID has been on their ability to work, and how they were going to adapt. But getting back to what employees want, it seems to me that technology is a really large issue when we access employees' desires. But a couple of things really focus out. One of them is, of course, now that we're accustomed to remote work in many instances, we want flexible and staggered hours. And of course, employees want to be reimbursed for their utilities and related expenses of working from home. They want work from home equipment that actually works and enables them to do their jobs without breaks or network breakdowns or technology breakdowns. And one of the things that has come to the fore, and a lot of companies have risen to meet the challenge, are new resources to increase team collaboration. There is so much new software on the market, it's just unbelievable. And the focus really is, how do we enable employees to collaborate when they can't do it in person? Some of the pain points throughout all of this, again, has been technology, slow home internets, whether virtual tools are available or not. Again, folks seem to miss the in-person collaboration the most. And then, of course, difficulty accessing tools and resources to do their work. And one of the things I like to tell employers is we need to shift from assessing where people work to what they do. Again, we no longer care where people work, we care about what they do. And so how do you evaluate employee capabilities and then provide them with the best ways to help them fulfill their obligations and to do their jobs? And the pleasure point in all of this is, if technology works, then employees can actually be much more productive. They actually are working longer hours, and the life balance that they're getting from this really is demonstrated by those who no longer have the 2-hour commutes, or those who deal with other things that are basically wasted time on a regular basis. I do recall early into this pandemic, I and a number of my attorney colleagues, many of whom work in large cities but live outside of them, we were all, how are we going to do this? And then as time passed, we all became accustomed to working remotely. And now that found time, no more commuting, it's just a pleasure. So we go from this new normal to a new future, and we look at the concept of how do we adapt, and really, again, focusing on what people do as opposed to where they are. Unfortunately, we're looking too at the Great Resignation. And the Great Resignation, I think NPR recently called it the Great Reshuffling. I heard that article, by the way, NPR, and I liked it. But in the meantime, the Great Resignation is very interesting because COVID-19 financial benefits, including both extension and enhancement of unemployment benefits, resulted in many workers making more than they would have made working. Now, this is starting to dissipate, But it's true that personal wealth increased during this time, and it allowed the workers the luxury of rethinking their careers. But really, it's interesting to look at some of the statistics. A record 4.3 million people quit their jobs in December of 2021. That is 3% of the workforce. Prior to that, an even bigger, well, the record really was set in November when it was 4.5 million, but it went from 4.3 million in August, 4.2 million in October, 4.5 million in November, 4.3 million in December. People are quitting their jobs, but that doesn't mean that they aren't taking other jobs. They are moving from place to place, and hiring is on the upswing at this point in time. As of the end of November, there were 10.6 million open jobs available for all of these people who were trying to move on. So who is moving on? Workers really have become choosier about the type of work they're willing to do. Although with the end of the extra benefits, again, we're starting to see more open jobs being filled. But according to the Society for Human Resources Management, over 40% of US workers are actively searching for a new job right now, or they plan to do so soon. This is interesting. And when you think about who's thinking of leaving, we're seeing younger workers, including millennials and members of Gen Z. They're more likely than members of Gen X and baby boomers to say that they're actively searching for a new job right now. In addition, it's been determined that Black and Hispanic workers are more likely than white workers to say that they're actively looking for new employment opportunities. Workers in professional and business services, technology and administrative roles are most likely to say that they're actively searching for a new job compared to workers in other industries. And if you think about, what these types of folks do, what these types of jobs are, many of them are accommodated in the remote sector. So what we're really seeing that the highest voluntary turnover, though, is in operations, customer service, logistics, hospitality. And the primary reasons that people are leaving is for better compensation. There's so much competition for the workforce right now that folks are able to get signing bonuses. They're able to walk into better paying jobs. But better work-life balance is a large part of this. Being home for COVID has taught them that they can work, but they can also have a better work-life balance. Of course, there are negative aspects to being home and having to deal with home life, but we'll talk about that briefly later. Most people, in addition to better pay, are getting better benefits, and they're seeking career advancement opportunities and just in general a desire to make a career change. Employers are responding, of course, as I indicated earlier, they're trying to adapt, and they're adding new or additional remote work or flexibility options, employee referral bonuses, sign-on bonuses, merit increases, spot bonuses, and really generally exploring what makes me an employer, what would make my culture something that an employee wants to stay at. How do we keep people here? How do we keep them engaged? And it's very important to try to focus on what it is that employees want. And part of that, and I'll talk about this later when it comes to recruiting, hot topic, but really talk to your employees, communicate with them. It's important to find out what is making them move on, what is letting them stay with you, and so forth. But either way, let's take a quick look at what the two different labor and employment agendas are between our presidents. Basically, I'm saying that the Great Resignation is impacting labor policy, and labor policy has an impact on that. Remember, COVID started during the Trump administration and has continued into the Biden administration. And so labor policy has had to adapt to the concept of COVID and so forth. When we look at these two gentlemen, we see two extremely different labor and employment agendas with extremely different goals and outcomes. So this is just a reminder here of where we were and where we are now. Recall that under the Trump labor agenda, the focus was on deregulation, rolling back all of the non-business friendly regs and executive orders, rolling back many of the Obama era executive orders and other employee protections that had been put in place, attempting to reform immigration laws, weakening labor unions, and basically short-circuiting the Department of Labor enforcement activity. This shows in the year-by-year decrease in various enforcement audits, charge filings, and the decreasing pipeline of back wage retrievals that I'll show you in some statistics a little bit later on. But for the most part, during the Trump era, we saw budget cuts, agency downsizing, and rollbacks. The DOL had many fewer resources for investigation and enforcement, and it pushed it towards a much more conciliatory and educational stance. And so what we saw was more outreach, more education and clarification before cracking down, much less punitives, more conciliatory, more flexible interpretations of the law. And in essence, I don't like to always use the concept of dumbing down, but we saw a number of the agencies basically hobbled. OSHA was shelved. The National Labor Relations Board was emasculated. The EEOC and the OFCCP had budget cuts and basically were pushed into working more on policy than enforcement. Either way, the agencies did their jobs to the best of their abilities during that period, and they still continue to retrieve back wages and assist employees and so forth, but it was nothing like it had been during the Obama administration. The Biden labor agenda is extremely different. It's a 180-degree change from the Trump agenda. And in essence, it's the same thing. We're going to now reverse multiple Trump-era executive orders, reinstate, if not reinstate, then reinstate the concepts of multiple Obama-era executive orders, strengthen pay equity laws, increase the federal minimum hourly wage from $7.25 to $15, reinvigorate the NLRB, strengthen unions and the ability to unionize, encourage family-friendly legislation, restore the broad definition of joint employer, increase gig worker and independent contractor protections. We're going to be focusing on the misclassification issues with respect to independent contractors. Mr. Biden would like to eliminate, if not otherwise limit, non-compete and no-poach agreements. And of course, mandatory arbitration has been under attack for a long, long time, and that's not going to change anytime soon. And I've gone the wrong way. Here we go. So when we focus on the Biden labor agenda, we ask the question, can it be successful? Will his policy reforms be successful? Will the Democrats have more luck in the Senate? I laugh only because even with a majority, they're not making much progress. And then short of effective support from Congress, can Mr. Biden achieve many goals? And I hearken back to what Mr. Obama consistently said: if we can't pass new laws, we will simply reinterpret the ones that we have. So we really are looking forward to a number of things. And I'd like to quickly touch on a couple of things that Mr. Biden is focused on. Apart from these items that I've listed, there are a number of bills in action that have been rattling around for a long time. There's something called the Equality Act, and it's one of the big ticket items on the discrimination front. It's basically a sweeping LGBTQ rights proposal that would update all the civil rights statutes to explicitly protect people from bias based on sexual orientation and gender identity in various contexts. If enacted, it would codify and expand the U.S. Supreme Court's ruling from last year in Bostock versus Clayton County, Georgia. I don't expect this bill to pass. This bill has been around for a long time. The thing that it has going for it this time around is the Bostock ruling. But this bill, it likely won't pass. There's a lot of arguments in essence saying that it's not necessary because All of this rolls into sex discrimination generally anyway, but it's out there, and I think there's a lot to be said about the fact that it's been out there for, I'd say, more than a decade, as I recall. The next one is called the Protecting Older Workers Against Discrimination Act, or Powada. And in essence, here, this would be a congressional action to lower the causation standards that plaintiffs need to meet to pursue age bias claims. In essence, people who sue their employers under the Age Discrimination in Employment Act currently have to show that age was the but-for or decisive reason for an adverse employment action, like a firing or a demotion. And this bill is intended to substitute the so-called mixed motive standard for their claims, meaning that they would have to show only that age was one of the factors behind any alleged mistreatment. And again, this is a much lighter test than the but-for framework. The other aspect of this bill is that it would soften the causation standard for plaintiffs to bring valid retaliation claims under Title VII of the Civil Rights Act or disability bias claims under the Americans with Disabilities Act by adopting a mixed motive standard there as well. I doubt that that one is going to pass because it really would open the door to a tremendous flood of litigation. And our workforce is aging, and so many parts of the workforce are well over 40 years old by now. Unless they raise the age limit, I don't see that one passing anytime soon. Another one that might pass is the Pregnant Workers Fairness Act. If enacted, this bill would require businesses with at least 15 people to make reasonable accommodations for workers who are pregnant. It would also forbid employers from making hiring and other employment decisions based on the need to make accommodations for pregnant workers, and would require them to rely on a reasonable accommodation process that tracks a similar process to the Americans with Disabilities Act. The big one here for President Biden is the PRO Act, the Protecting the Right to Organize Act. I guarantee you that this will not pass in its current permutation, but I think what's going to happen is they're going to dissect it, and each little piece of the PRO Act seems okay, and they're going to try to pass bits and pieces of it. If it or any portions of it pass, it could usher in the broadest expansion of federal labor rights since the National Labor Relations Act was passed in 1935. But this would really have a strong impact on the ability of unions to organize, and it would basically provide something called the ABC test for analyzing whether workers qualify as independent contractors, and that would be similar to something that has been adopted in California. So I just wanted to highlight some of these ideas and tell you what to look for. And again, keep in mind, as Mr. Obama said, and as Mr. Biden says, if we can't pass new laws, we will reinterpret and reapply the ones that we have. So what we've seen thus far is quite a bit of activity from Mr. Biden, and especially upon taking office. He moved very quickly to issue numerous executive orders. They seem to be the fastest way forward. So he signed substantially more than 65 of them since this time last year. But some of his recent executive orders and related actions are called the path out of the pandemic. And these include a lot of those vaccination mandates that we'll talk about later under our hot topics section. But again, this has been his approach to getting things done quickly and attempting to regulate at least the federal contracting portion of the employer workforce that he can regulate. He doesn't have the authority to do a lot of other things besides regulate federal contractors, as we just saw with the OSHA emergency temporary standard being shot down as exceeding authority. And again, we will talk about that in a few moments. In the meantime, what happened in the 2020-2021 term for the United States Supreme Court. Remember that the Supreme Court terms begin on the first Monday in October. So this again would have been October of 2020. The term ended in June of 2021. And these are the four primary cases that have some impact on labor and employment. They're not cases that have, everyday interest to employers, but they do set the table for understanding where our current Supreme Court is going. I think the most important two there are the Fulton versus City of Philadelphia case. And in that case, basically, the court held that Philadelphia's refusal to contract with Catholic Social Services for the provision of foster care services unless it agreed to certify same-sex couples as foster parents, that action could not survive strict scrutiny, and it violated the free exercise of religion clause. So the Supreme Court is saying that the city of Philadelphia must allow Catholic social services to place children with only not place children with same-sex couples. So that one is important because it highlights the court's perspective with respect to the free exercise of religion and whether a government entity like the city of Philadelphia can interfere with that. The other one that I think is important is Van Buren, and that's important more to attorneys and litigators because there's a law called the Computer Fraud and Abuse Act, and what we were seeing was anybody that accessed information that they didn't have a right to was being sued under the Computer Fraud and Abuse Act. And here the court held that the act covers those who obtain information from particular areas in the computer, such as files, folders, or databases, to which their computer access does not extend, but it does not extend to individuals who have improper motives for obtaining information that is otherwise available to them. So what this really means is that if an individual goes into files, folders, and databases, but their access is not permissible, they go where they're not supposed to go in order to get that information, the Computer Fraud and Abuse Act would apply to them. However, if somebody goes in there and has that access, but takes the information for inappropriate use, the Computer Fraud and Abuse Act does not apply to them. Again, this is going to have the impact of cutting back on a tremendous amount of litigation where the Computer Fraud and Abuse Act is utilized. And it's utilized a lot because it has, great damages. But let's move on to the Supreme Court 21 to 22 term. This began in October of 2021. And these are the cases that I think are the most important to watch. And there are some updates on all of them. For example, the Badgerow versus Walters case was argued early in November. And this has more to do with, again, the Federal Arbitration Act. And the question is whether the federal courts have subject matter jurisdiction to confirm or to vacate an arbitration award under the FAA when the only basis for jurisdiction is that the underlying dispute involved a federal question. Again, those of us who are arbitration watchers care about this case. The next important case here is Hughes versus Northwestern University. This was decided in January, on January 24th of this year. And in essence, in this case, the court surprised us a little bit and determined that just because participants in these retirement plans had an opportunity to make some decisions, just because they had that opportunity, did not mean that the defendant had satisfied its fiduciary duties as to the investments and services that were challenged by the plaintiffs. So the fiduciary duty rule continues, and I believe that it's been enhanced by the Hughes versus Northwestern case. The next case is Cummings versus Premier Rehab Keller. This has to do with whether compensatory damages that are available under the Civil Rights Act and the other statutes that incorporate its remedies for victims of discrimination include compensation for emotional distress. Believe it or not, that's kind of an open question. And this case was argued November 30th, And court watchers are saying that the court appeared open to this concept. So it's possible that we'll see more emotional distress damages claims anyway, whether they're able to access them or not, that'll be another question. And then finally, the Cvs Pharmacy Inc. versus Doe, very important and interesting case. However, it has been withdrawn by CVS. They withdrew the case in November, and I think that was a smart move on their part because difficult facts make difficult case law, and this was a difficult case to begin with. Let's move on to last session's blockbuster case, the Bostock versus Clayton County case. In that situation, we had the U.S. Supreme Court held that under Title VII of the Civil Rights Act of 1964, sex discrimination encompasses sexual orientation and gender identity, and gay and transgendered people are protected from workplace bias based on the concept of sex. So as a result, sex discrimination has been defined or more broadly defined. And so this case was a trio of LGBT cases or bias cases. It included the Bostock case, a case called RG and GR Harris Funeral Homes versus EEOC, and then Altitude Express versus Zarda. And in each case, there was a finding either based on an individual's gender, on their sexual orientation. And what happened is that a circuit split ensued. And so in the 11th Circuit, the courts found that sexual orientation is not covered by Title VII. In the Second Circuit, New York, basically, sexual orientation is indeed covered by Title VII. And in the Sixth Circuit, there was a finding that gender identity is covered by Title VII. So a circuit split is typically a good reason for the Supreme Court to take a case. And there was also an agency position split between the EEOC and the Department of Justice. And since the Department of Justice enforces EEOC matters, this became a very ugly situation. During the Obama administration, the DOJ and the EEOC were on the same page with respect to whether sexual orientation and gender identity were covered by Title VII. And then after the Obama administration ended, the DOJ's position went 180 degrees differently. And so the resolution of an agency position split became important for the Supreme Court as well. So since Bostock was decided, it has had a very wide-reaching impact with a growing number of federal courts applying its analysis to other federal sex discrimination statutes to protect LGBTQ plus folks in schools, housing, and healthcare. So it's not just employment discrimination where Bostock is having an impact. In addition, the Biden administration, within his first month in office, issued an executive order directing every federal agency to implement the Bostock ruling. And at the same time, we're seeing a lot of hostile state legislatures across the country pushing a record number of anti-trans bills. Many of them are targeting trans youth. And the ongoing fight to pass the Equality Act, which I mentioned earlier, again, which has been around in some permutation for over a decade, that's going to continue. So it's interesting to see how far-ranging Bostock has been, and I think that it's more opened the door for additional actions as opposed to, tied up something with a bow. So keep watching that as well. Let's turn quickly to some significant employment-related agency and regulatory developments. And these are the agencies that I'm going to touch on briefly for the most part, just to give you a flavor of what happened over the course of 2021 and what we're expecting to see in 2022. So let's take a quick look at the EEOC. And I'm using the EEOC charge statistics for 2020 because the 2021 charge statistics have not yet been included on the charge statistic website for use by people like me. In essence, there's a website that shows all the different statutes and all the different charge statistics for those statutes. And there is a tendency on the Democratic side, the administrations, to cease providing some of this information and possibly cut back. So I don't know if we're going to see that website updated anytime soon. The information is available in some of the other materials that the EEOC provides, but for the most part, we saw that total charges for 2020 were down by substantial numbers over the course of the prior 10 years. And when you look at 2013, when EEOC began tracking LGBT-based sex discrimination charges, you've seen an increase of only about 1,000 charges. So that tells you that a lot of the charges aren't coming to the EEOC or weren't coming to the EEOC. They might have been dealt with in other fashions or before state agencies. It's possible too that, you know, people are filing fewer charges as they become more aware of their rights and employers are heeding those rights. But I do think that a lot of the drop too stems from the Trump administration's kind of just pushing down a lot of this and people maybe even thinking that it wasn't worth trying anymore. I will say though that for 2020, retaliation, disability, race, and sex discrimination charges continued to account for the largest proportion of claims. And I think that retaliation, you know, if you as an employer have ever dealt with an EEOC or a state agency charge, retaliation is now commonly put in with every other charge. So you're going to see retaliation continue to be the leading edge of all charges going forward. But these are just some interesting statistics, and the EEOC certainly was successful in dragging in quite a bit of money in 2021. $484 million is in back wages is nothing to sneeze at. So, but I do expect for 2022 and the following years, the EEOC is going to go on a tear, and we're going to see substantially higher wage recoveries for employees going forward. Even these pent-up cases, perhaps that haven't been filed to date, we'll see more action there. Let's move on to the EEOC guidances that have come out. And again, these are by way of simply highlighting some things that have been issued. And the first one there is actually from 2020, but it was good to see a guide for employers and veterans with respect to the ADA, a useful document. And then in June, on June 15th, 2021, the EEOC issued this protections against employment discrimination based on sexual orientation or gender identity. Again, that was the anniversary of the Bostock decision. It was symbolic, but it does discuss these issues. And it's a useful document to take a look at if you want to educate yourself further about that. Some other EEOC issues, interesting. The EEOC technical assistance about COVID, the ADA, and other EEO laws. This has been continuously updated since it was issued in March of 2020. I check back on that on a regular basis. The most recent updates were November of 2021, had to do with retaliation, and then December of 2021, a discussion of when COVID-19 may be a disability. That's pretty useful as well. Another thing that employers have watched over the years is the EEO1 report, the Component 1 data. Remember that the Component 1 report is a mandatory annual data collection that requires all private sector employers with 100 or more employees and federal contractors with 50 or more employees to submit demographic workforce data, including data by race, ethnicity, sex, and job categories. So the EEO1 report, the Component 1 data for 2019 and 2020 had been on October 25th. It was extended to November 15th. And then I'm assuming that all of you who needed to do that did that timely. And then the component 1 data for 2021 is tentatively scheduled for April 12th, 2022. I imagine that that will change a little bit. You may recall a couple of years ago the horrific ordeal having to do with the additional data that they had requested, having to do with about 12 pay bands and breaking down compensation by race and sex. Well, some of that data had been collected, and then the rest, the EEOC withdrew its wish to continue collecting that. I think that's coming back. One of the reasons why is that the Office of Federal Contract Compliance Programs has indicated that it is going to use the 2018 data that the EEOC collected to actually try to identify contractors for audit. And with the new cooperative behaviors among all of these agencies, I think that we're going to see the component 2 data demands coming back. So gear up for that potential fight. I don't know if it's going to happen, but I wouldn't be shocked to see that rear its ugly head again. And it was ugly. And then the other thing that I wanted to point out is that the EEOC is it's got a new initiative on artificial intelligence and algorithmic fairness, and that has a lot to do with, again, ways of seeking compliance, and they're going to be looking at employment hiring and recruiting decisions there at this point, whether employers are actually using some of these softwares appropriately or whether they're paying any attention to it whatsoever. So watch for that in terms of those of you who are doing a great deal of, online recruiting. In fact, that's just about every employer today. So before I get off of EEOC, I just want to remind you of what I call COVID-related collateral damage. We've seen a lot of damage, a lot of collateral damage, but when I think about that, I think about women and caregivers, and I think about the Asian American and Pacific Islander community. The AAPI community was being subjected to a lot of anti-Asian sentiment when COVID first reared its head, and throughout at least 2020, the Asian flu and all of the other things that were being attributed to China as the heart and soul of COVID. I just want to remind you that the AAPI community continues to be subjected to anti-Asian sentiment through harassment, discrimination, and hate crimes. And whatever you can do to think about that or provide support is important. We go back up above that to the collateral damage for women and caregivers. Recall that women, over 80% of caregivers are women in this country. And so during the pandemic, more women than men, especially women of color, had to quit their jobs, reduce their work hours, take unpaid leave, all of this to care for children and other folks who needed their care. And the uncertainty of work and school schedules really took its toll. And of course, there is a concern that women will take steps backward in their careers, including in wages. That is definitely being borne out. Hopefully that can change as we become more accustomed to remote work and paying attention to these issues. But I just like to remind people of some of this collateral damage. Let's talk briefly about wage and hour enforcement activity. As you can see, back wage collections for Fair Labor Standards Act violations for fiscal year 2021 were fairly substantial. $164 million. It's nice. It's not a lot. But the continued focus really is on low wage industries. So those of you in agriculture and construction and food services and hospitality and retail are going to continue to be on the chopping block. And in fact, here's a list of low wage industries that continue to be targeted. I'd like to point out that the Department of Labor has added or is about to add 100 investigators to the Wage and Hour Division. This is part of, again, the resurgence of the Department of Labor. And here with Wage and Hour, we're going to start seeing a resurgence of audits and really focus not only on overtime, but really on misclassification. Misclassification is going to be the big ugly this year for Wage and Hour audits. If we look at government contractors, they had back wage collections for the Service Contract Act, the DBRA, and so forth. And again, that's 48 million. That money is typically subsumed within the Fair Labor Standards Act statistics as well. And here again, the focus is typically on low-wage industries with government contractors, but that really, you're going to be zeroing in a lot on guards, guard work, janitors, but a lot of the tech workers as well. And the focus on tech workers is going to be more about whether they are recording all of their time worked and so forth. So as a federal government contractor, it's always great on an annual basis, at least, to kind of renew your relationship with the Service Contract Act and the Fair Labor Standards Act, renew your advice to your employees to record time worked and to report their hours in an attempt to avoid the potential for underreporting or for folks who simply don't record their time because they don't want to for whatever reason. Just think about that and act on it if you happen to be a government contractor. Some other issues with Wage and Hour. We saw and are going to continue to see activity based on overtime thresholds and what I would consider to be a potential review of the duties tests. Remember that every minimum wage increase requires an act of Congress. Our current minimum wage is a pathetic $7.25 an hour, and that was passed in 2007 and took effect in 2009. So we've had that same minimum wage for over 12 years. However, even though this would require an act of Congress, the Fair Labor Standards Act does allow the Department of Labor to issue rules that shape overtime eligibility criteria for some types of workers. And so you'll recall, of course, the big fight having to do with the white collar exemptions and the spiking up and dropping down of the earnings threshold, which is currently $35,308 per year. I believe that we're going to see an attempt to raise that number again, to raise that threshold. And if that threshold can't be raised, then I think that we're going to see messing around with the duties tests for the exemptions. So keep an eye on that. And we're going to see issues having to do with the dual jobs rule and more issues, more guidance on tip pooling. And so the tip pools and the dual jobs rule kind of go hand in hand for hospitality, particularly restaurants. We've seen some telework pay guidance, which is basically a combination of basic wage and hour concepts that were put into a telework pay guidance fact sheet. Nothing new there. Joint employer status, the Trump era approach to it has gone away, and Mr. Biden's DOL is coming back with joint employer status, whereby just about everybody is your employer. Just watch out for that. We're going to be seeing more focus again on misclassification and independent contractors. And I would say that the DOL opinion letters, which I was very grateful to see them during the Trump administration, unfortunately, many of them have been rolled back already. And there's no assurance that the Biden administration will continue to issue DOL opinion letters. Again, we often see a dropping off of this kind of useful tool during a Democratic administration. Now, moving on to the Ofccp, lots of stuff going on there, but kind of little chunks. So the Combating Race and Sex Stereotyping executive order issued, I believe it was in August or September, where Mr. Trump was focused on keeping employers from providing workplace diversity training that made white people feel uncomfortable. That executive order has been rolled back. There was also a final rule having to do with the religious exemptions, and the OFCCP is rescinding that. Basically, they're not making special provisions for religious employers. Basically, discrimination is discrimination. It doesn't much matter to the OFCCP whether you believe in one thing or another. If you're an employer and you employ employees, and not all of your employees, have your same thoughts and goals, then you have to apply the law to them equally. The next topic there is stepping up enforcement with a focus on disability and pay equity. Be aware that the OFCCP and the EEOC, again, are banding together to focus on not only the artificial intelligence issues, but a number of algorithmic approaches to pay equity and compensation. And then the big ugly here is some new reporting requirements. We're basically going to see, well, something new that is happening is called the System for Award Management. The OFCCP is enforcing affirmative action compliance by requiring contractors to verify through the System for Award Management, the SAM database, that they have developed and maintained their affirmative action plans. This is a first. Employers have never had to do this in the past, and this is new. And so what it will include is a SAM declarations page where the contractors will affirm that they have developed and maintained affirmative action programs at each establishment as applicable. So some compliance dates on that for this initiative: March 31st of this year, contractors will have access to the portal to certify their affirmative action planning compliance. And by June 30th, contractors must certify whether they have developed and maintained their affirmative action program for each establishment or functional unit as applicable. So be aware of that. It's brand new, and it's going to simply put employers in the position of not only making these affirmations, but actually paying some attention to their affirmative action plans. I do a lot of affirmative action work for federal contractors, and the ones that have methodized it, they do it annually. It goes smoothly. It's easy. Those who just have something on the shelf that they haven't looked at in over a decade, they really need to pull that off the shelf and start focusing on the current requirements of affirmative action, and really getting your reporting and record keeping up to date. It's really all about recruiting, more so about recruiting and opening up your applicant pool than anything else. And it's not hard to do once you understand how to do it. So keep that in mind if you're a federal contractor. Some other aspects. The National Labor Relations Board. Oh, I'm sorry. Let me run back to the OFCCP for a second. Another topic. This is a scary new proposal, and this is not yet in. It's not yet in action, but be aware of this. Under the Department of Labor's Fall 2021 regulatory agenda is a proposed rule that would add provisions to the regulations that implement Executive Order 11246. And this would require contractors to provide notice to the OFCCP when they award supply and service contracts. Basically, this kind of information is not available to the OFCCP because contractors typically make those awards and then rely upon the subcontractors to determine whether they themselves are subject to Executive Order 11246. Here, by providing the OFCCP with this information, the OFCCP will have the opportunity to reach down to subcontractors and thereby expand its regulatory footprint. So again, another really important issue to be aware of if you're a federal contractor. All right, if we look at the National Labor Relations Board, We see that the Republican majority has given way to a Democratic majority. It doesn't just signal a major shift in favor of workers, it is shifting in favor of workers. And the agency has signaled that it will be very activist. This is going to be a hot National Labor Relations Board. It's got staff who are dedicated NLRA workers. They do good work, but I am a little concerned as an employer side attorney that employee handbooks are now going to come back under intense scrutiny. That was, to me, such a comedy of I don't know. I didn't appreciate it. I wouldn't say errors, but it was awful, and I don't want to see that happen again. But I think it's going to. So employers, even non-unionized employers, are going to come under intense scrutiny for their employee policies and employee handbooks. Watch your student athletes and organizing rights. That is going to be just an interesting thing to watch as the year moves forward. We're going to see again as the NLRB kind of drills down on attempting to prevent employers from restricting employee. We're going to start seeing protection for worker outbursts again. Under the Obama administration, we saw people who engaged in bad behavior get protected under the National Labor Relations Act. Under Trump, all that went away, and now I suspect it'll be back, but possibly a little more tempered. We really can't, with all the violence in our workplaces today, we really can't take chances. I think that we're going to see a lot more leeway for union organizing and related activities, and that's the PRO Act again. So watch these things. Expect the National Labor Relations Board and the EEOC to cooperate as well. There's a goal among the DOL agencies to do a whole of employment investigation and audit approach. So we are seeing these little memoranda of cooperation among the various agencies, EEOC and Ofccp, NLRB and EEOC, and so forth, where they will pass information back and forth to each other in an attempt to identify, let's say you have one employer, and this will attempt to identify multiple areas to look at in that employer's employment and how they handle employees. So watch out. We're going to be seeing a lot of interesting cooperative activities among the different DOL agencies. Now, OSHA, I'm going to hit that under the vax stuff, but I do want to say that they were repressed for 4 years. They weren't permitted to get involved in the pandemic in terms of attempting to make rules or rulemaking, standard making. They certainly did issue a number of guidelines or guidances, which were the gold standard for employers to follow during the pandemic. But we saw that OSHA was oftentimes at a cross purpose with the CDC in terms of the levels of protection that were thought to be important by one agency versus the other. So again, I'm going to hit a little bit more of that later. But one thing under OSHA that I think we need to be aware of is workplace violence. Workplace violence is truly a realistic threat regardless of the size of the workforce, the industry, or the location. And OSHA defines workplace violence as any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that occurs at the work site. And so, like harassment, workplace violence can range from verbal threats and abuse to physical assault, and in this case, even homicide. And it can occur both in or outside the workplace, and it can affect or involve not just employees, but clients, customers, and visitors. And so we're seeing OSHA focusing in on potential workplace violence, a standard, hopefully. And there are some high-risk categories based on where the employee works and what they do. And some of the most vulnerable are workers who exchange money with the public, such as retail workers and bank tellers, healthcare professionals, individuals who work alone or in small groups, such as delivery drivers, utility workers, and cable installers, and those who work at night and in high crime areas. And so workplace violence can occur anywhere, anytime. And they focus on guidelines for violence prevention programs and are working with the U.S. Department of Homeland Security as well to attempt to focus on enhancing some of the workforce violence guidelines. So I think that OSHA has provided a great deal of information and advice for employers, but it's never too late to start focusing on a violence prevention program in your workplace. And basically under OSHA, the building blocks for developing an effective program would include management commitment and employee participation, a work site analysis, hazard prevention and control, safety and health training, and record keeping and program evaluation that are appropriate for that workplace. And these are the building blocks to any OSHA program. So keep that in the back of your mind. We're seeing so much more violence that we're starting to really focus in on employers and their particular violence prevention, or at least violence reaction programs. A lot of our banking clients go through violence training on a regular basis where they're subjected to, feigned violence or feigned robbery. It's robbery training and so forth. It's important, and it helps people to think about things more clearly when they do happen. Let's talk a little bit about some prognostication here, because I know that I am running a little short on time. But when we look at 2022, and the next couple of slides really just have a look at them. But we're going to see more of everything. Everything is going to continue in the way it's going now. The Biden administration is going to continue to attempt to not only roll back some of the Trump era orders, but they're going to reinstate a lot of the Obama era orders and concepts that had been rolled back. We're going to see a movement of the OFCC back to an enforcement posture. EEOC is going to continue to get the retaliation charges. And as you can see, I think we're going to see a high incidence of online harassment charges, because that's where people are these days. There's a lot to be said about online behavior that I'm not touching in this program, but it's getting bad. States, there's this patchwork of state laws having to do with pre-employment bans, salary history, credit history, criminal background information, and so forth. You've got to stay abreast of that if you are in more than one state. And again, more of everything, more wage and hour audits, more equal pay audits. Again, independent contractor misclassification and joint employer reviews are high on the list of the Wage and Hour Division's to-do list this year. And then we've got, again, another patchwork of minimum wage, whether it's state to state, municipality to municipality. Again, we've got this patchwork that ranges from $7.25 an hour all the way up to almost $20 an hour in some of the northeastern states. So we have to stay abreast of all of that. Strength, basically, as I said, change is big, and we're going to see strengthening of the Department of Labor agency, the multiple agencies under the Department of Labor. We're going to see more enforcement, more focus on work-life balance and family-friendly legislation. OSHA is coming back, and they're coming back big. And I, for one, welcome them, because they truly do great work in the workplace. And that's hard maybe for some of you defense folks to hear, but I am a fan of OSHA. And again, just all of these things, we're going to see ongoing COVID-related issues. That's just going to be with us now until it goes away. And then, what's the next big pandemic? Remember, too, OSHA is working on an infectious disease standard as well. So, as I said, this time last year, tremendous change was coming then. It began immediately in January, and it continued throughout 2021, and it's going to continue throughout Mr. Biden's administration. We're going to see more change, whether via executive order, agency activity, congressional actions, or judicial interpretation. So stay buckled up. So moving on, I'd like to hit some hot topics. I understand that time may be limited, but I'd like to hit them anyway. My slides are quite explicit here, so to the extent I don't delve into everything thoroughly, the slides should be useful. So these are where we're going to go. Let's start with the COVID-19 vaccination mandates. These are the three that have been pretty in the news lately. They're going to talk about their current status, and what employers should be doing regardless of their status. But first, maybe I'm naive, but let's start with a question. Wouldn't it be nice if employers had one set of rules to follow, one entity to blame for unpopular vaccination, testing, and mask requirements? One standard instead of the multitude of states and municipal standards that apply depending on your location. Wouldn't it be nice? Well, we don't have that. The OSHA emergency temporary standard that was issued pursuant to President Biden's order, it was issued in November. It was shot down by the US Supreme Court finally on January 13th. And in essence, it went through multiple injunction proceedings and ultimately ended up in one of the circuit courts that won the lottery, basically, to make that decision. There were so many circuits where injunctions had been granted. So in essence, the US Supreme Court finally indicated that the Secretary of Labor lacked the authority to impose the OSHA mandate. And the court basically focused on the fact that while OSHA empowered the Secretary to set workplace safety standards, this particular emergency temporary standard was instead a broad public health measure. The majority opinion, shooting it down, said that although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. The Supreme Court's majority opinion described the OSHA ETS as a blunt instrument applied without drawing any distinctions based on industry or risk of exposure. So this is the way it was viewed, as opposed to attempting to provide a safe workplace. It was more about what it didn't do and so forth. So OSHA withdrew the ETS. It was withdrawn as an emergency temporary standard effective January 26th. However, it is now out there as a proposed rule. So it's open to comment, and OSHA will continue working on this proposed rule, and it is prioritizing its resources to finalize a permanent COVID-19 healthcare standard. So this standard, while it was it was a difficult standard, and I personally found aspects to it that I didn't like, of course. But it's important to look at that standard because the ETS provides an outline of what we can anticipate seeing. It might be softened down with some of the comments that will be received by OSHA. And as OSHA works forward now to create a permanent rule, they might relax some things and add information elsewhere. But let's take a quick run through what the standard said so that you can prepare for it. It was a 100 employee threshold, and it included part-time, full-time, remote, and multiple sites. I expect that to continue, although I wouldn't be surprised to see it apply to all employers going forward. That 100 employee threshold really missed a tremendous number of employers who could have used the same kind of one rule approach that this would provide for all employers. So I would expect to see that threshold change. Now, there was a full vaccination requirement and masking requirements. And then if you couldn't be vaxxed or wouldn't be vaxxed, you had to undergo testing at least once every week, and you had to wear a mask at all times while at work. I think we're going to see some permutation of that going forward. but there might be the ability to relax that to some degree or find other solutions. Now, what it did provide was paid time off for workers to get each vaccine dose and to recover from their side effects. But it tried to incentivize people to get vaccinated by providing for no paid time off for testing unless it was required by law or collective bargaining. And then, of course, no paid time off for workers who test positive and can't come to work because, again, the goal was to incentivize vaccinations. And again, saying people who had already had COVID and had some of the antibodies would still have to get vaxxed. What else did it require? This is where it got a little bit overburdensome in terms of some of the record keeping. There was very explicit record keeping, and a lot of employers were up at arms more about the record keeping than about the actual requirements for vaccination, masking, and testing. So I would expect to see some potential relaxation or revision to the record keeping rules. And of course, the ETS would have expired in 6 months unless modified by OSHA or replaced by a permanent standard. And that's where we are now, seeking to replace that failed ETS with a permanent standard. And of course, states that have their own OSHA plans must have a standard of their own that is identical to or as effective as the OSHA standard. And if they don't, then they have to use the OSHA standard. And of course, states without state plans would have been subject to the OSHA ETS as well. So that is the OSHA ETS. Stay abreast of this, and I think that you're going to see it happening. I still think that OSHA can push a COVID workplace safety in the wake of the Supreme Court ruling while it seeks to establish that new standard. In essence, don't forget that employers are bound by the general duty clause, and all employers are required to provide a workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm. Based on that, OSHA has the authority to inspect workplaces for violations, and it does maintain COVID-19 enforcement data. In addition, OSHA has its standard, the updated guidances. It's a continually updating guidance called Protecting Workers Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. And it applies to all industries other than healthcare. But in essence, it's really the gold standard for setting up your workplace. OSHA also has a COVID-19 national emphasis program, and this is in addition to and not instead of any emergency temporary standard or other final rule that comes. So that means that there will be increased inspections and enforcement in targeted industries. And so I expect to see the national emphasis program getting a little bit more play now that the emergency temporary standard has been shot down. So we're expecting to see more general duties clause citations relating to COVID-19 violations of the CDC guidelines, and then a resurrection of the permanent infectious disease standard that the Obama administration had developed. Unfortunately, they left office before they were able to get it in place, but that's coming as well. So that'll take a while to get out the infectious disease standard because it'll be way broader than COVID, but that's coming too. All right, so that's where OSHA is. Now, with federal contractor protocols, remember that Executive Order 14042, the path out of the pandemic, had required federal contractors to have everybody vaccinated. There was no vax or test rule. This was pure vaccination. And in essence, in this case, the nationwide injunction was issued by the 11th Circuit on December 7th. And so the federal contractor mandate is currently on hold, but it's involved in the usual court runaround, so briefing, further actions. There's a potential for a decision on this in the next few months. So be aware that it isn't dead yet. Nobody is required to adhere to it generally, although there are some exceptions at this time, and that it may be resurrected. We'll see what happens. If I were in charge of this particular standard or protocol, I would be willing to make a couple of renovations to the protocol because I think that it's much too strict. It requires all federal contractor employees to be vaccinated, no exceptions. And I don't think that that's appropriate or fair, particularly given the types of workplaces we're dealing with. And then, of course, we've got the exemption issues that so many employees are raising. And I don't think that it's fair to federal contractors to make that requirement because it puts them in a very severe bind. Now, even though it's on hold, there may still be some obligations with respect to access to government facilities. Some of those facilities require vaccination and testing, regardless of who your contractors are. This is what it takes to get into this facility, so you have to do it. So that might still be an issue for a lot of the contractors. And I do think that you should stay vigilant because it appears to me that we're likely going to see something in the near future. I would say that, again, having entered into I know what happened. Some of the contracts that contractors signed before this injunction went into effect actually did put them into that position of having to have fully vaccinated workforce. So there are some contractors who actually did sign those federal contracts with those provisions in them. So some of those folks might still have to obey or abide by this. Regardless, they should remain vigilant because something is going to change. And so again, this is a very brief couple slides that tell you what the protocol had required before it was shot down. And that little line at the bottom, agencies are strongly encouraged to include the clause in contracts below 250,000. Yeah, we saw a lot of that. A lot of contractors didn't say yes to that though, because they didn't have to. And remember that this does not apply to grants or subcontracts solely for the provision of products or work performed outside the US or contracts below 250,000. So there are some exemptions. Just be aware of it. I think that it's going to come back in some form or other at some point. I think it'll come back in a slightly less restrictive form, particularly with respect to the pure vaccination requirement. Now let's talk about the CMS healthcare employee vaccination requirements. This is what was required. The Centers for Medicare and Medicaid Services had issued its interim final rule in early November, and that required healthcare staff vaccinations for facilities that were under Medicare and Medicaid programs. It was a condition of participation, and healthcare workers were to be fully vaxxed in 2 phases. Of course, we're well beyond those phases at this point, so this is where we are now. The Supreme Court lifted the injunctions against the CMS vaccine mandate when it shot down the OSHA mandate. So this was January 13th of 2022. And of course, now they changed the compliance dates, although one of them is passed already. The January 27th was the compliance date where all of the workers that were subject to this must have had their first vaccination. And then February 28th is where the primary vaccination series must be completed by, although in many cases that booster will have to follow. But so the first shot by January 27th, and then the finishing off of the primary vaccination series by February 28th. And I like the way CMS said this: hey, we preempt any conflicting state laws because it's our money, and this is a condition of participation. So covered employers must comply. So let's talk briefly about who these people are. Again, who is a covered facility? A covered facility basically would be a number of things, but ambulatory surgical centers, hospices, psychiatric residential treatment facilities, programs of all-inclusive care for the elderly, hospitals, all kinds of hospitals, acute care, psychiatric hospitals, swing beds, long-term care, children's hospitals, transplant centers, cancer hospitals, rehab hospitals, long-term care facilities, including skilled nursing facilities, intermediate care facilities for individuals with intellectual disabilities, home health agencies, comprehensive outpatient rehab facilities, critical access hospitals, clinics, rehabilitation agencies, and public health agencies that provide outpatient physical therapy and speech language pathology services, community mental health centers, home infusion therapy suppliers, rural health clinics, end-stage renal disease facilities. Does not apply to physician offices. So that's probably the most relaxed aspect of this rule. Individuals who are covered are basically all applicable providers and suppliers. Staff is broadly defined to include facility employees, licensed practitioners, students, trainees, and volunteers, and individuals who provide care, treatment, or other services for the facility, its patients, under contract or under arrangements. So it's very, very broad. Now, the implementation and timing of this, again, is the February 13th was to provide, excuse me. Okay. The timing changed a little bit there, but we've got the compliance phasing in there, and it's to be implemented in 2 distinct phases. January 27th, again, you get your first dose of a primary series or a single dose of COVID vaccine. And then by February 28th, you have to complete the primary vaccination series unless they've been granted an exemption from the vaccine. All right, and then the exemptions themselves, there are exemptions for staff with recognized medical conditions for which vaccines are contraindicated, again, as a reasonable accommodation under the ADA or religious beliefs, observances, or practices. CMS has an FAQ guidance on this, and though it recognizes these exemptions, it emphasizes the fact that no exemption should be provided to any staff for whom it is not legally required or who requests an exemption solely to evade vaccination. And so, you know, this, just hearkening back a moment to the federal contractor and OSHA mandates, I expect to see the implementation of exemption language similar to this. You cannot provide against allowing exemptions for people because otherwise they will lose their jobs, and it will be a direct result of what could be a disability or a religious objection. So these exemptions are important to understand and to adhere to. And then with respect to enforcement, CMS intends to enforce the vaccine mandate through existing state survey procedures. So for now, that's really where it is. You know, non-compliance could subject providers and suppliers to a range of remedies, including civil money penalties, denial of payment for new admissions and patients, or termination of a Medicare/Medicaid provider agreement. But again, it's going to be through the existing state survey procedures. So there may be a little bit of lag time in terms of any ability to enforce kicking in. All right. And so with respect to these issues, I wanted to remind you too that there are other issues relevant to an employer's implementation of vaccination requirements, things that all employers should be thinking about. And that has to do with not just religious and medical exemptions to vaccination requirements, but the costs. How are you as an employer going to deal with testing costs? Will you pay for time off for testing and vaccination? Will you pay for time spent for temperature checks on the employer premises, one of the big wage and hour arguments right now, we're seeing a lot of litigation in this area, is whether people who have to wait to have their temperatures taken or otherwise go through basic testing before they can come into the workplace, whether they're entitled to be paid for that time spent. And then other things to be looking at in terms of costs and other things have to do with your insurance policies and where COVID might hit you with respect to your insurance policies and what you provide for your employees. So those are the OSHA and vaccination issues I wanted to chat about. There are more hot topics here, and I'm just going to list a few things for you because I know I've extended well beyond my time here. But why not? Let me just give it to you. Some wage and hour issues to worry about in 2022. Again, it goes back to what I said earlier. I expect to see an increase in the salary threshold for the overtime exempt employees. Currently, that threshold is $35,308 per year or $684 per week. If that number doesn't go up, the 35,000 number doesn't go up, then I think we're going to see Department of Labor revisit the duties rules for exemptions and a tightening up of those rules. They are a little bit loose. They remain subject to interpretation, and there's a lot that can be done to make it more painful for employers to exempt people from overtime. We're going to go back to the expanded definition of joint employment. And the way I say it, basically, everyone is liable depending on who is defined as an employer. The reason why joint employment is appealing to wage and hour is because they need to find somebody to pay employees who should be paid back wages. And sometimes the payor is not really an employer under the law. So we look to see whether there's a staffing agency, whether there's a secondary contractor, and we look to them to pay those employees. Independent contractors and the gig economy, ongoing and more attention to these folks to try to provide them with more protections. There is a presumption in this Wage and Hour Bureau. There is going to be a presumption of employee status unless proved otherwise. So presume employment, prove otherwise. And then, as I indicated earlier, we've got another 100+ investigators coming online, which will enable Department of Labor to do a tremendous more amount of wage and hour audits and investigations. And some other hot topics for 2022, which we could probably devote a couple of other hours to this, but recruiting and retention. We're looking at the concept of remote work, remote recruiting, remote interviews. How do you onboard people? How do you, have them collaborate? How do you retain people when you can't really spend a lot of time with them? There are a lot of tips for retention, and a lot of it really boils down to communication and finding out what people like, what they don't like, how can we improve, what do you need, how can we help you, and making it worth their while to communicate with you about what makes them happy and what doesn't make them happy, whether they're a flight risk or not. As I indicated earlier, the Biden administration is against restrictive covenants and no poach agreements. So I think that we're going to see a move in not only the federal government to start restricting the opportunity for an employer to use non-competes. We're going to see some legislation around the country that begins to restrict the use of non-competes. For example, in Pennsylvania, the legislature has before it a bill that attempts to eliminate the ability of a hospital or other system provider to limit physicians from going to competing organizations. So we're looking at potentially trying to eliminate restrictive agreements for physicians and other medical providers, and that would expand after we see some success with something like that. Then the no poach agreements, really that's where employers can't agree with each other not to steal each other's employees, because it restricts the ability of those employees to move around, to get better jobs, to get more pay, to move forward in their careers. So those are going to likely go away before restrictive covenants do, but I think they're both in the same sinking boat. And then finally, with cannabis. Cannabis is a complex area, and every state has its own law. Any state that has legal cannabis, whether it's just medical or whether it's medical and recreational, cannabis law in the employment arena is currently governed by each state's statutes. And depending on how well drafted those state statutes are, you're going to see litigation of all kinds to almost no litigation. So I would say, with respect to cannabis, just get straight in your own minds what it means to accommodate, whether you're a drug testing company or not. How do you handle medical marijuana? And do you have policies in place that you can point to that support any behaviors or actions that you do take with respect to medical marijuana users? With that, I think that I need to move out of my presentation and open it up to questions. Catherine, I think that I've said as much as I can for now, and I'm leaving it to you. Thank you very much.
Okay, Catherine, thank you so much. This was a really very informative webinar, so thank you. I think we have time right now for one question, and then I would encourage our attendees to look out for an upcoming radio show and podcast that we're going to be doing for additional questions. So the first question I have here is remote work here to stay?
In a word, yes. At least for employers who can accommodate remote work. As I indicated earlier, I think that there are a lot of employers that can't accommodate remote work. And then, of course, there's the hybrid type where some workers must be in person and others can be remote. But I do think, to the extent an employer is able to have remote work, I think it's here to stay. And some of the big issues really are about adapting your employment processes to this new normal. And so we look at every employment process that an employer uses and try to assess, how does that apply where the person isn't really here? So we focus on recruiting and virtual recruiting and interviews. And how do we really assess a person if we can't see them in person? It's not so bad on Zoom or Teams meetings at this point. I think we're all accustomed to doing that now, but still there's nothing like that in-person meeting. So again, how do we make accommodations and adapt for virtual or remote recruiting? And then onboarding that person once you've decided to hire them. And how do we go about onboarding them? We can send them all the employee handbooks and things to sign that we want, but how do you introduce them to your team? How do you make them an integral part of a team and a collaborating colleague? There's all kinds of fun stuff to consider here. And then, of course, performance. We really are reverting over to performance as the measure of somebody's actual, how we judge their performance. So productivity is the key. How do we judge performance? And that gets you into rewriting your job descriptions and reassessing expectations for remote employees and how much work that they need to produce. Or, is it volume? Is it substance? What is it that you're seeking from your employees? So it gets back to productivity as opposed to how many hours they're working or what time of day they're working. Are they producing the work that they're supposed to be producing? Is it working? Now, of course, we have these behavioral issues. When we do have meetings, we've got people with their little side chats, or they're making fun of other people on screen. They're making nasty comments. Those are just, kind of minor issues. But then, of course, you've got the people who are going to find new ways of harassing their coworkers. When you're in person, it's one thing. You can say things, you can be physical. When you're remote, there's just a whole raft of new things that we're seeing, new creative behaviors to harass your colleagues. So we've got to identify those and determine how to identify and how to stop those, because even though everybody's remote, it doesn't stop an employer from having obligations to prevent harassment and discrimination in the workplace. And then, of course, that leads you to the concept of, how do we apply discipline to people? How do you know if somebody hasn't shown up for work? How do you know, if they've done something that you would typically discipline them for during an in-person work day? And that gets you back, of course, to the concept of productivity. So we have to kind of reassess discipline. And of course, there's everything else, whether it's discharge or performance reviews, or any of the other things that an employer puts into assessing its employees and building those relationships, career advancement, discipline, all the things that go into having an employer-employee relationship have to be rethought and reassessed in light of the concept of remote work. So I think it's a big ask for a lot of employers, and it's something that everyone has to do, and I'm hopeful that everyone can do it successfully now that we're well into remote work.
I wanted to thank you for being here today. It was our pleasure, so thank you.
Thank you very much. I appreciate it.
Attendees, please use the contact information that you find in the slides. Think of questions afterwards. You can send those to us. Please remember your PAYCOM and your PMI CEU certificate will be emailed to you from within 2 days following the broadcast. There's no need to request it. You can register for future webinars or request a demo of our compliance solution on our website at firsthcc.com. or call us at 888-543-4778. And thank you for joining us.